It doesn't matter if my client is destitute or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need is a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here.
Every single expense that she listed, she deems as estimated. Every expense without a single exception.
The vows said, "Till death do us part," but what about the finances? A recent legal battle raises profound questions about spousal support and the expectation of maintaining a marital standard of living indefinitely. Join me as we explore the biblical principles of fairness and self-reliance in the context of divorce and financial obligations. Does need really mean the same as accustomed to?
What do we need to do today?
Your Honor, if I may, I think my motion to compel is the oldest file. We filed that back in November. Mr. Olson has filed a motion to compel in January, motion for spousal maintenance modification in January 29th, a motion as to an advancement of funds, January 29th, and a motion as to the Denali and advancement of funds dated February 28th.
If we need to set an in-person hearing, which is my preference on, when we've got multiple notebooks and so forth, we'll do that. But if there's something that we can get accomplished today, I would like to do so.
Your Honor, if I may.
Go ahead.
In listening to Mr. Olson and in my comments, we may be able to resolve the motions to compel outside of a hearing. I may need court intervention on some objections that Mr. Olson filed, but that should not take long. I think we need an in-person half day to address all of these different matters, Your Honor. I don't know what we can accomplish on the Zoom hearing, except it would be as a discovery, but I think we might be wasting the court's time because I think Mr. Olson and I can figure out 80% of it at least, if not 100%, on the discovery issues.
I'm fine with moving the discovery issues, Your Honor. We're still here. We've got 50 minutes. We can at least take even if it's the motion to modify spousal maintenance, we are more than capable of dealing with that over Zoom and handling that this afternoon, so we don't have to continually drag this out and move it to another date, which I'm sure will probably be early to mid-April. We're ready to proceed.
Sorry, Matt. That's okay. Your Honor, as the motion for spousal maintenance, that's going to involve competing experts. That is not something we're going to be able to do over Zoom, Your Honor. And that also ties in with the motion to compel and for advancement of funds, and also the Denali, Your Honor. We have issues involving the domestic relations affidavit filed by Ms. Yost, and I think she's going to need to be sworn in to go over her expenses. She claims $4,000 a month, every month, for attorney's fees, Your Honor, amongst one of several expenses that are questionable. So this is not something that is appropriate over Zoom.
Give me a second to review. And Angela?
All right, everyone. It's good to be with you all again. What's come to my attention is a case where a former spouse is seeking a substantial amount of money. We're talking about $99,000 per month from her ex-husband. The justification seems to be rooted in her desire to maintain the lifestyle she was accustomed to during their marriage. This, my friends, raises some serious questions from a conservative Christian perspective about responsibility, entitlement, and the very definition of need. One of the central arguments being made by the requesting party's representation is that need is a standard of living. They contend that it doesn't matter if the client needs a smaller amount for basic survival. If she was accustomed to a higher quality of life due to her spouse's income, then that becomes her need.
I misplaced my docket notes. They're buried on somewhere in here. Can you have the ability to print those out for me, please? Now, the expert witnesses, what motions were those for?
We disclosed we had an income analysis done of Mr. Yost, Your Honor. That was disclosed on January 17th through Jeff Querin. So the only part of the motion that we have dealt with that obviously is the motion to modify spousal maintenance. If the court would recall, initially when we filed this case, we're the petitioner, we had set spousal maintenance at $9,000 a month. And the court actually called me, this would have been through the ex parte temporary order, inquiring as to when the last year of tax returns we would have had available at that time, and that was 2018, which Mr. Yost at that time had made significantly less than what he had made over the last 3 years that we've averaged. So at the time, maintenance has been set based off of an income of Mr. Yost around $338,000, $318,000 or somewhat. And the report we've had from this income analysis that Jeff Querin has done 7 weeks ago has his income average over the last 3 years at $664,000. So again, that's not brand new news. Again, that report was issued and sent to Mr. Thompson within a couple of days, if not on January 17th. So I mean, there's been ample time to respond to that. Frankly, if we're disclosing expert reports by statute, Mr. Thompson would have had to have a responsive expert opinion within 30 days of receiving notice of us issuing that report. So that's not been done. We're outside the 30-day window. So I really don't know what the dispute is on this motion with respect to the spousal maintenance, besides trying to continue to delay this matter. So again, we're ready to proceed. It's all argument. There's not any need besides the domestic relations affidavit, which is a sworn statement. There shouldn't be any need to question anybody on the witness stand. If this can be done through argument.
Your Honor, and I disagree completely. If we review Ms. Yost's domestic relations affidavit, every single expense that she listed, she deems as estimated. Every expense without a single exception.
In this specific instance, the husband, Mr. Yost, makes a significant income, and it's explicitly stated that the ex-wife believes he is supposed to pay for her lifestyle, ignoring the fact that they no longer share the same roof. Now, as Christians, we understand the concept of husbands providing for their wives within the marital covenant. Scripture is clear on this. However, once that covenant is dissolved through divorce, the nature of those obligations shifts dramatically. To suggest that a former spouse is perpetually obligated to fund a specific standard of living simply because it was attained during the marriage is a precarious and, I believe, unbiblical position.
As the expert report, if I have a reply to their expert report pursuant to the rules of civil procedure, that's 30 days. I can have an independent expert, separate and apart, Your Honor. I have a demonstrative exhibit, which I anticipate. Let me try to be as succinct as I can. We cannot get this done in 45 minutes. Any one of these motions, Your Honor. Any one. The domestic relations affidavit is riddled with, they're all estimates. I'm entitled to inquire of Ms. Yost as to what her actual expenses are, because she has not provided a single solitary actual expense to justify any deviation from the court's order of spousal support. None, Your Honor. Everyone's an estimate. And the court cannot make a determination based on pure estimates by the party requesting a modification of her own spousal support award.
The lawyer representing the husband rightly points out that every single expense listed by the ex-wife is an estimated every expense without a single exception. This lack of concrete, verifiable expenses to justify such an exorbitant demand is deeply concerning. We are called to be good stewards of our resources and to be honest in our financial dealings. Relying on vague estimations, especially when seeking such a significant financial commitment from someone who is no longer your spouse, lacks the accountability that should characterize all our interactions. It appears, as the husband's side argues, that these random numbers are being used to try and extract more money.
There's no case law to discuss that, Your Honor. Estimates are commonly used because the DRA has to be filed prior to the time of trial. Usually most pretrial conference orders require 10 days in advance of trial or 30 days, depending on the court and jurisdiction you're in. At that point in time, it's very common practice to have the exact amounts put in. Otherwise, you put estimates in. That is something I've commonly done in 15 plus years of domestic practice. And frankly, if we're talking about my client's expenses and we want to get into the analysis on spousal maintenance, it really doesn't matter because need doesn't have to show. Of course, we're talking about need versus ability to pay. Clearly, there's an ability to pay, If we start talking about need, it doesn't matter if my client is destitute or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need is a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here.
The idea that her need is directly related to how much her ex-husband makes is particularly troubling. True need, in a fundamental sense, should be tied to the actual cost of living and an individual's ability to meet their basic requirements. To tie it solely to the former spouse's income suggests an entitlement based on past association rather than present reality. As one commentary aptly put it, she is no longer his wife. You can't leave someone and expect to take their lifestyle with you. We also see a specific instance of a claimed $4,000 a month every month for attorney's fees. It's hard to fathom expecting your former spouse to continually finance the very legal efforts you are undertaking against him. This raises questions of fairness and personal responsibility for one's own legal costs after a separation. As someone astutely observed, having to pay for the attorney arguing against you is crazy and should not be a thing.
Again, there's been ample time for Mr. Thompson to respond to Dr. Querin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day-long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support. And the court cannot make a decision when every, not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly $4,000 a month in attorney's fees for every month. But, Your Honor, we're putting the cart before the horse.
The legal proceedings themselves reveal the husband's side is seeking detailed information about the ex-wife's actual expenses, indicating a legitimate concern that her claims are inflated and lack factual basis. The fact that the initial spousal maintenance was set at a much lower figure based on the husband's past income further underscores the dramatic increase being sought now that his income has reportedly increased. While an increase in income is a factor to consider in spousal support modifications, it should not automatically translate to funding a previously enjoyed lifestyle, especially when the requesting party appears capable of contributing to their own support. From a conservative Christian standpoint, we believe in the dignity of work and the importance of individuals striving for self-sufficiency. The notion that a divorced individual should endlessly rely on their former spouse to maintain a certain standard of living, rather than making efforts to adapt and provide for themselves, seems to contradict this principle. As one insightful remark notes, time for her to start acclimating to the lifestyle she can provide for herself. She needs to go to work.
I didn't say a day. I think it can be done in half a day. The court does not have the ability. I don't think the court has the ability to make an informed decision based upon argument when there are all of these issues and all of these issues with the documents that have been submitted. We have over 300 pages of exhibits, Your Honor, for a status conference. That is not status conference material, Your Honor. That's a half day in person, as this course procedure has been throughout this case and the other cases I've been involved with, Your Honor.
All right, if you all can give me just, I'm going to take a short recess. All right. I understand, Mr. Olson, you're wanting to get this stuff resolved. I want to get cases resolved probably more than you guys do. But this is a status, and this is what we're doing. We figure out, has anything been resolved? What do we need to do? Well, it doesn't sound like anything's been resolved, that we just need to set everything for hearing. And but I want to set an afternoon, and it'll be an in-person hearing, and we'll take up everything that we can that has not been resolved at this hearing. Any other matters, Mr. Olson, from your perspective that need to be addressed today?
Yeah, but the court's already told me we're coming back on April 30th, so I understand and appreciate that. Not beyond that, Your Honor. No, sir.
All right, and Mr. Thompson?
No, Your Honor, thank you.
From a conservative Christian standpoint, we believe in the dignity of work and the importance of individuals striving for self-sufficiency. The notion that a divorced individual should endlessly rely on their former spouse to maintain a certain standard of living, rather than making efforts to adapt and provide for themselves, seems to contradict this principle. As one insightful remark notes, time for her to start acclimating to the lifestyle she can provide for herself. She needs to go to work. It's also worth noting the procedural aspects, where the husband's lawyer is seeking in-person hearings and expressing concerns about resolving complex financial matters over Zoom, particularly when expert testimony is involved. This suggests a commitment to thoroughness and ensuring all evidence is properly scrutinized, which is crucial when dealing with significant financial claims based largely on estimations. The delay in the ex-wife's team responding to the husband's income analysis also raises questions about the urgency and justification for the current demands. In conclusion, what we see in these excerpts is a situation where the concept of spousal support seems to be stretching far beyond its intended purpose of providing necessary assistance after a divorce. The demand for a substantial sum to maintain a past lifestyle based on estimated expenses and tied to the former spouse's current income presents a challenge to the principles of personal responsibility and financial accountability that are so central to our Christian faith. While compassion and fairness are important in divorce proceedings, they should not be interpreted as a perpetual entitlement to a former spouse's earnings. The focus should instead be on enabling individuals to establish their own sustainable and responsible financial futures. Thank you for joining me on the Black Tea Podcast. Let's continue to think critically about these issues and always ground our perspectives in biblical truth. God bless.